Rejecting prospective residents based on criminal history may violate fair housing laws. Throughout the United States, individuals with criminal records, regardless of whether they pose little or no threat, face significant barriers when seeking to buy or rent a home. Amazingly, between 70 million and 100 million Americans, or as many as 1 in 3 American adults, have some type of criminal record. And while many have been convicted of only minor offenses, having a criminal record carries a lifetime of consequences. This often includes an inability to secure housing. The Federal Fair Housing Act prohibits discrimination in the sale, rental, or financing of dwellings, and in other housing-related activities on the basis of race, color, religion, sex, disability, familial status, or national origin. Ex-convicts and individuals with a criminal history are not explicitly identified by the Act as a protected class. Nonetheless, the United States Department of Housing and Urban Development, HUD, recently opined that housing providers rejecting tenants or buyers based on their criminal records may violate the Fair Housing Act. At its core, the issue is whether exclusionary policies based on criminal background checks have an unfair or disparate impact on certain racial minorities who are protected under federal laws governing housing. On April 4, 2016, HUD's Office of General Counsel issued guidance concerning how the Fair Housing Act applies to prospective buyers and tenants with criminal records. According to the opinion, landlords and sellers must differentiate between arrests and convictions and must steer clear of blanket policies that restrict access to housing solely on the basis of criminal history. HUD's opinion does not mean that housing providers are entirely prohibited from considering criminal records. However, they must now ensure that their screening policy is necessary to achieve a substantial, legitimate, non-discriminatory interest. As HUD notes, a housing provider must, however, be able to prove through reliable evidence that its policy or practice of making housing decisions based on criminal history actually assists in protecting resident safety and/or property. To meet this burden, housing providers must consider factors like the nature and severity of the crime, as well as the length of time since the conviction. By conducting this analysis, housing providers can establish that their policy accurately distinguishes between criminal conduct that indicates a demonstrable risk to resident safety and/or property and criminal conduct that does not. At the heart of HUD's opinion lies the doctrine of disparate impact, sometimes referred to as unintentional discrimination. Pursuant to this doctrine, a policy may be considered discriminatory if it has a disproportionate adverse impact on a protected class. For example, a policy that applies to everyone may still prove discriminatory if it tends to affect a protected group or minority more than others. As applied to its position on criminal history-based restrictions, HUD notes that across the United States, certain minorities are arrested, convicted, and incarcerated at rates disproportionate to their share of the general population. As a result, restricting access to housing on the basis of criminal history is likely to have a disproportionate adverse impact on racial minorities, who constitute a protected class. HUD's guidance also outlines the 3 steps considered when analyzing claims that housing was denied on the basis of criminal history. 1. Whether the policy or practice has a discriminatory effect. 2. Whether the policy or practice is necessary to achieve a legitimate, non-discriminatory interest. And 3. Whether there is a less discriminatory alternative. If nothing else, landlords and property managers should take the time to update and revise their screening policies to ensure that their use of criminal background checks does not act as an arbitrary and overbroad ban on those with criminal records. All criminal records are not alike, and not all ex-convicts pose a risk to safety or property. And now, housing providers who do not take this into account may find themselves on the wrong side of the law. Fair Housing Act, Criminal History-Based Practices and Policies. In the recently issued Office of General Counsel guidance on application of Fair Housing Act standards to the use of criminal records by providers of housing and real estate-related transactions, the U.S. Department of Housing and Urban Development, HUD, urges housing providers to exercise caution when implementing criminal history policies or practices used to make housing decisions. HUD's guidance comes on the heels of the Supreme Court's decision last summer, which held disparate impact claims are cognizable under the Fair Housing Act. While persons with criminal records are not a protected class under the Act, HUD stresses that criminal history-based barriers to housing have a statistically disproportionate impact on minorities, which are a protected class under the Act, and as such, creating arbitrary or blanket criminal-based policies or restrictions could violate the Fair Housing Act, FHA, or Act. To be clear, HUD's guidance does not preclude housing providers from crafting criminal history-based policies or practices, but the guidance makes evident that housing providers should create thoughtful policies and practices that are tailored to serve a substantial, legitimate, and non-discriminatory interest of the housing provider, such as resident safety or the protection of property. HUD includes context for its guidance and offers statistical evidence that the United States minority population experiences arrest and incarceration at rates disproportionate to their share of their population. For instance, HUD asserts that in 2014, African Americans were incarcerated at a rate nearly 3 times their proportion of the general population. In the context of criminal history policies or practices, disparate impact liability is determined using a burden-shifting framework that first requires a plaintiff or HUD to prove that the criminal history policy or practice has a discriminatory effect, meaning the policy or practice results in a disparate impact on a group of persons because of their race, national origin, or other protected characteristic under the Act. In this step of the process, the evidence must be provided that demonstrates that the criminal history policy or practice actually or predictably results in a disparate impact. If successful, the burden then shifts to the housing provider to show that the policy or practice in question is justified. Here, the housing provider must show that the policy or practice is necessary to achieve a substantial, legitimate, non-discriminatory interest of the housing provider, and further, that the policy or practice actually achieves that interest. Finally, if a housing provider is successful, the burden shifts back to the plaintiff or HUD to prove that the housing provider's interest could be served by another practice that has a less discriminatory effect. The determination of whether a criminal history-based policy or practice has a disparate impact in violation of the Act is ultimately a fact and case-specific inquiry. However, HUD's guidance provides insight into how to create a legally defensible policy that does not violate or frustrate the FHA's prohibition on the discrimination in the sale, rental, or financing of dwellings or in other housing-related activities. We recommend a review of HUD's guidance, but have distilled that guidance to assist in reviewing existing criminal history-based policies or practices or in the creation of a new one.